Hello and welcome to the latest webinar by Lexplosion Solutions Private Limited on the latest version of the Digital Data Protection Act. As most of you would know, the Digital Data Protection Bill was tabled in first the Lok Sabha and was passed by the Lok Sabha, and then was tabled in the Rajya Sabha and was passed by the Rajya Sabha as well. More recently, it has also received the presidential assent. So for all import and purpose, the Digital Data Protection Act is now an enactment. However, what we need to keep in mind is that the rules are yet to be notified, and the actual Gazette notification is also yet to come, which means that we probably have somewhere between 3 to 6 months as businesses to get our houses in order before this act actually starts having a direct impact on our lives. The IT Minister, Mr. Vaishnav, in a recent interview to the Economic Times, broadly laid down that it will take a few months to have all the rules in place. So I think 3 to 6 months, sometime around the end of March or early April, is probably a fair expectation in terms of timeline as to when this act will become law. So which is why we thought it's an opportune moment to actually introduce the key concepts from a business perspective, so that all of us get some time to get ourselves prepared. I'd like to take this opportunity to thank all the people who have decided to join our webinar session. I hope that you find this fruitful, and I hope you have many questions that we can answer either towards the end of the session or once the session is over email. With that, just broadly speaking, what we need to keep in mind is, while this is probably the first serious privacy law in India, this is not really the first time that India has had a privacy regulatory regime, because we've already had the Information Technology Act for over 2 decades. And specifically within that, the Sensitive Personal Data or Information Rules of 2011 dealt with certain types of, classified certain types of data as sensitive personal data, for example, passwords, biometrics, health records, and things like that. And they had to be dealt with by businesses already with a higher level of duty of care, including, following the ISO IEC 27001 certification, a re-audit, so on and so forth. Now, one of the interesting aspects of the Data Protection Act, as and when it's formally notified, is that it has done away with the SPDI rules. So as an outcome of that, we will have to obviously understand how the whole thing will play out. But as an outcome of that, the Data Protection Act will remain the key, the focal point for privacy laws in India. What also needs to be kept in mind is that the Data Protection Act specifically states that in case of a conflict between this act and any other law currently in force in India, the Data Protection Act will prevail, which essentially means that if there is a dissonance between this law and, let's say, guidelines passed by the DOT or any other department, let's say the RBI, then it's the Data Protection Act which will prevail over those laws, and that's a very interesting construct. Our primary focus today primarily will be on how to prepare yourself from a business perspective. We understand that there's an entirely different civil rights construct to this bill, and we all have our personal views on that. But that's not the focal point of today's discussion. We'll primarily focus on some key concepts. We'll talk about their evolution over the last few years. As most of you know, this is not the first version of this bill. There have been several before that, and my colleague Kanishka will give you the broad evolutionary history of this bill immediately after this. So today I'm joined in this session by Kanishka, as I mentioned, and by Abhishek, my two colleagues from Lexplosion. And later in the session, we'll be joined by two of our key advisory, key clients on the compliance management side, and their representatives. We'll have a representative from Hindustan Unilever and a representative from Eureka Forbes. Just by way of a statutory warning, all three of us in Lexplosion and our two guests who will join a little later are lawyers. So we will primarily talk as lawyers, but it needs to be clarified that none of us are representing ourselves out here as lawyers. So please don't take this as a legal opinion. This is neither a legal opinion nor the opinion of our companies. This is our personal opinion based on on the current version of the enactment, and we will obviously have more discussions as time goes by. With that, without any further ado, sorry, one more housekeeping point before I hand over to you, Kanishka, and my apologies for that. I just wanted to let the audience know that the session has been recorded slightly ahead of schedule to avoid any last-minute glitches. So, if you see that there is a jump in the visuals, it's primarily because of that. But we did not want to record it live because sometimes that creates problems. So, with that, Kanishka, why don't you give us the broad, evolutionary history of the data protection law in India?
Sure, thanks, Indranil. In fact, if you talk about the genesis of this act, it can be traced back to the Supreme Court judgment in the Puttaswamy case of 2017, right? And this is where the right to privacy was declared as a fundamental right, right? Soon thereafter, there was a committee headed by retired Supreme Court Justice P.N. Sri Krishna, was formed, and the committee also submitted its report in 2018, which was, which kind of laid the foundation for the first draft of the 2018, data protection bill. Right? The government, of course, have come up with 4 different iterations thereafter, which, of course, is leading up to the current Digital Personal Data Protection Act 2023. So here we are, in this session, what we would like to do is we'd like to go ahead and cover, certain perspectives which are applicable or relevant to the business.
Right. And I think that's what we now need to focus on, some key concepts, because, obviously there are lots of things in this bill, or rather now the act, but we need to cover some of the critical concepts from the point of view of what our our clients, our business partners now need to start thinking about. And what I thought we should probably cover are, first of all, the concept of data and how that has evolved, and how when we started in 2018, the concept was essentially all kinds of data. The 2019 bill actually went ahead and specifically covered offline data, which was a source of concern for a number of clients who deal with all sorts of offline data as well. But how that has now kind of modified itself from the 2022 bill onwards to primarily the digital data aspects. And also, what the 2018 bill did very well was introduce some concepts in terms of the key stakeholders, and those concepts have again remained the same through this entire journey of the bill. Fundamentally, I mean, there might have been some tweaks here and there, but the concepts of data principle, that's all of us individuals, because again, just to clarify, this law deals with only data of private individuals and not businesses. So all of us are data principals, and as principals, we have control over the data that we have. And that just by using the phrase, I think that was made very clear. And then, of course, the concept of data fiduciary, which is all of us businesses, and the fiduciary, by again just using that term, the duty of care that has been cast on all of the businesses which will deal with the data of data principals is significantly higher than usual. Then, of course, there are data processors who could be the data fiduciary themselves, or any third party appointed by the data fiduciary to process data, which includes storing of data. So, for example, cloud service providers would get covered. And then there's the concept of significant data fiduciary, and I know that we'll get into greater details when we talk about the current version of the bill. But it's a classification of a higher duty of care for significant data fiduciaries. All of these are concepts that have been carried forward. So has the concept of notice and consent, but that's kind of modified over time. And I thought, Abhishek, maybe you can give us a broad perspective of the journey of the notices and consents to the 2022 bill, and we'll come to the 2023 portion when we come to the current enactment.
So thanks, Indranil. Over and above the concepts of the key players, data fiduciaries, data principals, and data processors, there was also this novel concept of notices. And the 2018 bill introduced this concept of providing detailed notices to data principals while collecting their personal data, informing them of the purpose for processing, the right to withdraw consent at any point in time, and the right to redress grievances, and the manner in which complaint could be made to the Data Protection Board. And in that notice, businesses like us had to be clear about the exact purpose for which personal data was being collected and process it only for that purpose. For instance, let's say an e-commerce company which is collecting addresses of customers to be able to send them products that they buy, will not be able to use the data to do geographical or demographic profiling
Right.
unless it is clearly mentioned in that notice.
Correct.
And businesses also had to provide the option to data principals to access the information in multiple languages. And
Right.
we may take this up
So
few
Abhishek,
in.
I think to just in sum, the concept of notice and consent, while introduced in 2018, has seen some progress. For example, in the 2022 bill, there was a need for an itemized notice, a concept which has now been carried forward in 2023. There was a need for providing notice in multiple languages, and a key change between what happened in the 2019 and 2021 bill and what has happened now is that processing has to be only for necessary purposes, and we'll get into the concept in greater detail in 2020 when we talk about 2023. But now a consent has to be for a specific purpose. You cannot take a overarching consent and say that I could use your data for every purpose that is possibly envisageable, because that's not allowed anymore. But another concept which is undergone, which first of all shook the business community significantly, and then has undergone quite a bit of change over the last several years from 2018 till now, is data localization. And Kanishka, I was wondering if you want to just give us some perspective on how that journey has been.
Exactly. I think this was one of the most talked about, the most controversial concept that was introduced in 2018. It required businesses to store personal data in Indian servers, right? At least a copy of personal data in Indian servers. Further, stricter rules for sensitive and critical personal data, which had to be processed only within India, right? So it was very, very strict. And was not something that businesses were liking at the initial stage, or when the 2018 bill was released. However, this is a concept that has seen a lot of change from the initiation. So in 2019 itself, in the second iteration of the bill, it was majorly changed, right? So the mandatory requirement for business to store personal data in India was done away with. Right? Only it was limited to sensitive and critical personal data. In 2021, there wasn't quite an amount of change, but 2022, this requirement again saw a major change. So in 2022, cross-border transfer of data could be possible in countries which were notified, which would have been notified by the government. Of course,
Right.
it wasn't notified because the act did not come out, and of course, but in 2023, however, it again changes. So this is something which changed a lot, specifically from 2000.
And I think this is one of the cases where clearly the government has been fairly receptive to the inputs that have gone in from businesses, because especially organizations dealing with multiple countries and dealing with loads of data which crosses the border very often, maintaining storing all data in India, or at least one copy of all data in India, processing critical or sensitive data only within India was difficult. 2022 said that they will provide us a list of countries where the data can be shared. And I know that we'll come to 2023, but the main difference in 2023 is that data localization stands significantly diluted, as we'll see as we move on. And which brings us to the concept of right to nominate, Kanishka, which again first came in only in 2022.
Correct. So there was another concept that was brought in. So basically, of course, we understand what nominate means. Here again, as data principals, you could nominate certain individuals as your nominees who would enjoy the same rights as a data principal would have in case a data principal, is dead or is incapacitated. So
Right.
this again, brings in a new concept. If you consider obligation toward businesses, this brings in a lot of new
Yes.
challenges as well.
As a matter of fact, in this context, so right to nominate definitely comes with a fair amount of additional responsibilities on businesses to know who the nominees are, what are the circumstances in which information needs to be, they have this, they step into the shoes of the original data principal. A similar concept, again introduced way back in the 2018 bill, was with regard to protected people. And it started with just children, and that's how it continued even after the 2022 bill, where children could not just give consent. Their consent had to be had to be given by their guardian. So for every person who is a child who's accessing whose information you're accessing, there was a higher duty of care. What 2023 does, and I know we'll come to it in greater details, is adds another level of duty of care by adding people with disabilities, persons with disabilities, differently able people as a part of that group, which means that every time somebody is logging in, you will have to know about the status of the person with regard to whether they're a person with disability, and then give them the option of identifying a guardian. And in all of this kind of also leads up to the concept of a consent manager, which was introduced in 2022. And I do intend to ask our guests a little later today about the concept of consent manager, because many of our clients, many of the people attending today's call will be dealing with literally lakhs and crores of consents on an annual basis. And the concept of a consent manager as a digital, as a body which or a company which will be registered with the Data Protection Board, and which will have to then provide a solution which works across multiple platforms, multiple different ERPs, etc., might be a very interesting challenge. It will be worth talking to our guests a little later about that. So with that, we come to the 2023 enactment, which is the here and now. To start with, who does it apply to? So first of all, it applies to individuals, like I mentioned. So it applies to data principals, which is people like you and me. It only applies to digital data. So we have, at least for the moment, don't have to worry about physical data, but it also deals with non-digital data, which has subsequently been digitized. So as far as data residing in India is concerned, as far as companies operating from India is concerned, it applies to all people residing in India. It applies to all businesses which are dealing with digital data within India. It also applies to all digital data which has been stored and processed historically. So it's not just from the date of the enactment. It's all the digital data that currently resides with you. But it doesn't just stop there. It also applies to businesses operating from outside of India to the extent that they're dealing with Indian residents and providing them with goods and services. And if they're providing goods and services and in a digital form to people residing in India, so any kind of e-commerce, any kind of online services that you can think of will attract the Digital Personal Data Protection Act. What is interesting is the 2022 version also had a concept of profiling. So it specifically included profiling as an outcome of an international digital platform being also covered under the Digital Personal Data Protection Act. That has been deleted, which suggests that for the moment, the pure profiling of people, for example, for marketing purposes, probably stands excluded, at least from the point of view of people operating from outside India. With that, I would like Kanishka and Abhishek to take us through some of the key obligations under the 2023 Act with regard to data fiduciaries.
Indranil, I'd like to slightly add to that what would be considered offering of goods and services to an individual in profiling might need a bit more clarification.
Sure.
Because
So that is true. That is absolutely true, because profiling could also lead to sale of goods and services, and how that will play out is worth looking at. So yes. So with that, if we can quickly touch upon, and I know that we are running out of time, but if we can quickly touch upon the key obligations of the data fiduciaries before we introduce our guests to this conversation.
yes,
Sure.
and one more important aspect, which is kind of worrying, is that the fact that sensitive personal data as a concept has been dispensed with under the 2023 Act. And this may effectively end up casting a wider net of compliance obligations, as now the same duty of care, which would otherwise be applied to sensitive personal data or information, would need to be provided to a larger data set over and
Right.
above what
You make a very valid point, Abhishek, that earlier the duty of care was higher for only sensitive personal data or information. Now, whether you're collecting somebody's email ID or the health records, the level of duty of care has been made standard. But I think some of that will be taken care of through the concept of the significant data fiduciary. I know that we'll probably not have a lot of time to discuss it in today's conversation, but for those interested, we can have another conversation later. But we are hoping that with the concept of significant data fiduciary, which is actually being modified over the last few iterations, what will happen is that people collecting sensitive data, collecting large volumes of data, will be classified as significant data fiduciaries. And as a result of that, what will happen is those will have to be dealt with a higher degree of care. And that, we are hoping, will take care of some of the worries people have with the doing away of the SPDI rules. However, what becomes relevant from a business perspective is that earlier the significant data fiduciary also had a revenue threshold. It was above a certain revenue. Now that has been taken away. The outcome of that could be that even a startup which is dealing with sensitive data would have to have some of the requirements of a significant data fiduciary, which includes having a data protection officer, having appointing an independent auditor, and also actually conducting data protection impact assessment, which for a small company could become a fairly expensive exercise. But with that, if we can move back, and I know I'm sorry for having jumped the gun and moved to significant data fiduciaries. If we can come back to the key obligations of data fiduciaries, Kanishka, Abhishek, over to you. I must confirm that we are short of time, so we need to cover these key obligations as quickly as possible.
Sure, and I think talking about the key obligation, I think the main obligation for a data fiduciary would be to obtain consent through notice for all the data that they are collecting. In fact, not only data that they're collecting now, consent would also be required for data collected before the commencement of this act. Now, as a part of the requirement, as a part of the notice, what are the things that you need to definitely keep in mind? That what is the personal data that you have collected, or what is the personal data that you're processing? What is the purpose of processing the same? You'll also have to mention the rights of the data principal, which has been entrusted by this act, which includes things like the right to withdraw, the right to grievance redressal, and also the manner in which a data principal can take a complaint to the Data Protection Board of India. Right? Again, if you consider the consumer-centric organizations or the industries which would usually collect a lot of data, this I think overall do create a mechanism in order to send notices which would definitely have to be articulated well, where the process and the purpose of processing the data has to be mentioned well, is something that organizations need to go ahead and start working on.
And in the interest of time, if we can, so yes, itemized notice, very important. Consent for specific purpose, very important, because without that, you cannot just take an overarching consent and use data received for one purpose for something else. All of those will require a fair amount of additional work from every existing business in terms of identifying what purposes they need information from, making sure that they've specifically received consent for each one of them, having mechanisms to ensure that these consents have been duly, wherever the purpose has been is over, the information has been duly purged. All of those will be extremely important steps that they take. Back to you, people, for anything else that you want to talk about.
Indranil and Kanishka, for legacy consents, it's only possible to go back so far, so, do you
Right.
think that there'll be a time limit which is going to be prescribed under the rules?
Not
Would
sure
that
as of now, but logically there should be, because it would be rather difficult for organizations to go back decades from the time that they first started storing digital information. But we'll have to see how that plays out.
Again, one more thing, of course, we were talking about, the right to nominate, right? And maybe it's not expressly mentioned in the format of the notice that we were talking about, but I think this is also something that, data fiduciaries should start collecting as a part of their notice requirements, so that, in an event of a death or a encapsulation of a data principle,
Right.
the required consent can be obtained.
Right.
Now, with that, I'd like to quickly move on to the concept of legitimate purpose. And there are certain legitimate purposes for which a data fiduciary may be able to process personal data of a data principal without obtaining express consent for use of the same. And few of the relevant instances are where a data principal has voluntarily provided personal data to a data fiduciary. And it seems like data of candidates applying for jobs can be considered as legitimate use if such data has been shared voluntarily. And moving on to the processing of which brings me to the employee-related data. And in the previous version, as you may recall, employee personal data with regards to employment, recruitment, termination, verification of attendance, etc., could be processed without their consent. But now, under this present act, these seem to have been taken away. However, instances relating to loss or liability, such as prevention of corporate espionage, maintenance of confidentiality or trade secrets, intellectual property, have still been retained. And employers, from that perspective, may need to think about preparing for managing consent for data with regards to employment, recruitment, termination, verification of attendance, which I mentioned earlier.
Right.
And we'll see how this
So,
firms
so
up once the rules are notified.
So Abhishek, I think we have completely run out of time, so we'll stop. But I think you make a very important point with regard to employee data, biometrics, some of which were actually excluded under the 2022 bill as things which did not fall within the purview of this enactment. But now they've all been brought back. So especially for people who have not had the opportunity of looking at the 2023 enactment fully, this is something that as an employer you need to take care of. Earlier recruitment data with regard to employees, biometrics, termination, all of the performance indicators, all of that was excluded from the purview of this enactment. That is no longer the case. So that's something that you also need to keep in mind. I think with that, Abhishek, Kanishka, thank you so much for introducing some of these key concepts. I know that the half an hour is not enough, but I know that we also know that there are guests who have far more relevant inputs to provide. So I think it's time to move to that section of the webinar now. Thank you. It is time now to welcome our esteemed guests on today's panel, Ms. Mitali Basu and Mr. Bibhav Pradhan. Like we have already mentioned, this is a session which we have recorded slightly ahead of schedule. So when we actually take live questions, you will find that Ms. Basu is actually probably more ready to attend the session in court. But it is what it is, and we wanted to make sure that we have the advantage of having their inputs and feedback the moment they were available. To introduce, Mitali Basu is the General Counsel for Eureka Forbes Ltd. She heads the legal, compliance, and policy function for the company. Mitali has over 2 decades of experience, having previously worked with large organizations such as Crompton Greaves, Consumer Electricals Limited, and Parley Agro Private Limited. She has led legal teams, built compliance culture and organizations, handled major acquisitions, and ensured digitization of the legal function. She has been recently awarded the prestigious Top 100 General Counsels by BW Legal World. And we, of course, have Bibhav, who has been in a previous session on data protection with us. Bibhav is a lawyer who has spent over a decade in different capacities with the Unilever Group, first in Nepal and since 2013 in Hindustan Unilever in India. He's currently the data privacy lead for Unilever South Asia and also leads the legal team for the beauty and well-being business. Bibhav is a graduate from National Law School, Bangalore. He graduated in 2011. Thank you both for taking the time out from your busy schedules to share your views on the Digital Personal Data Protection Act. Let me start by asking both of you for your initial thoughts on the new law. Let me start with you, Mitali. Are you happy with how the law has finally shaped up? Are there aspects that you would want the government to relook at this late stage? Over to you, Mitali.
Hi, Bibhav and Indranil. Thanks for inviting me for this talk show on Digital Data Protection Bill 2023. Just to be, while it was much awaited, we right now have it on our table. Everybody is in the process of evaluating it. But there will be a lot of cost consequences. There will be a lot of back-end work, which all organizations, mostly with a customer interface, would require to be doing. Even the service industry will require a lot of manpower, man-hour input to it. What majorly is intriguing in this case is the protection mechanism. Now, there is no mention of what happens if the data is breached. So let's say the law enforcement, let's say the police, the role, it's not defined. It's not even mentioned. Let's say the role of the court of law. While we all know that CPC, CRPC may be under review by the present government, and we don't know what kind of incorporation will that bring in. This is almost like the consumer redressal forum kind of a setup that we are looking at, because you would have a data protection board. Timelines may be between 1 month to 6 months, and I don't see things, in case of data breaches, things really going very fast. So that's something which is not a very healthy part in the entire act, so to say, because redressal is one aspect which will come up, because every other day you will receive a complaint, because the knowledge will be delayed in percolation, and hence everybody would want to seek some form of redressal. Who do you go to? How quickly can you get those redressals? Are something which are not so far defined in the act, and that's going to become an impediment as we take this forward.
That's a very interesting and an important take, Mitali. I'm sure there are thoughts going into the redressal mechanism, but you're right. At the moment, there is not much available in terms of guidance on what it will be. Bibhav, your initial thoughts on the bill, or the act now.
Absolutely. I think, as Mitali mentioned, first of all, hi Indranil, hi Mitali. Really nice to connect with you both. I think I'm a little optimistic. While there are differing views, I'll speak about it from an organizational perspective. I'm optimistic because the government through these years have been quite amenable to consultations. And just to give you a few examples, if you see the 2022 draft that had come about some time back, there were some concerns from, not as an organization, we had some concerns whether it was the entire whitelisting for cross-border transfer, which would have made it a very difficult exercise. So cross-border would have become almost impossible only to countries which are whitelisted, has now changed to blacklisting this thing. Similarly, if you see the grievance redressal that Mitali spoke about, it's one of the most difficult one which we'll have to evaluate. But one of the concerning parts was a 7-day response timeline, which was provided. Now, if you see the act, it has been removed and it says as prescribed. Similarly, deemed consent has been reworded to legitimate use. So there have been, they're quite amenable to these. And then all of us as part of trade associations or individually as organizations have interacted and engaged with the government stakeholders to relay our concerns as well as suggestions and recommendations. So they've been amenable to that. But I said, while I'm optimistic, there are quite a few ambiguities that come about. Now, as we discussed last time, the government has taken a more simplified approach towards the act, with the regulation supplementing it subsequently to bring in clarity. And therefore, while I'm happy right now with how the government has approached it, being more practical, unlike a very stringent GDPR approach because of the prevailing context, that is the Indian context, right, and the organizations that exist here. Therefore, however, while being optimistic, I'm still really looking forward to the rules, and I'm hoping that the government would be as engaging that as they have been through these 5-6 years when they were developing and formulating this law.
That's a great insight. I mean, thank you so much, Bibhav. So, in fact, I'll just to add to that, and I have a question for you. In fact, of course, we are all looking forward for the rules, and that's when we'll exactly be able to go ahead and start preparing for it. But considering that it's already an act and it's received all the assent that it requires. As a data privacy advisor, as a senior legal counsel for a company as large as Unilever, what kind of preparations will you require to comply with this enactment?
So one of the advantages I have had because of being part of Unilever is that we are an Anglo-Dutch. We used to be, and we are based out of the UK. GDPR was something that was applicable, so it was an opportune moment when privacy was getting really ripe for discussion in India, somewhere around 2017 with the Aadhaar litigation. And that was when the GDPR just gotten implemented with a 2-year transition period, right? So Unilever was already in transition to prepare for the GDPR. And being a global organization, we benefited immensely in terms of knowledge transfer arising out of GDPR and implementation thereof, and also the global tools, platforms that got implemented across the globe. So that has been one of the advantages. But what I would state is that I think over the last 3-4 years, since 2018, when the expert committee started with the draft, that's when we started our journey. I think our senior management agreed that we would be preparing for the future and prospective law. So we were not only complying with the SPDI rules pertaining to sensitive personal data, but complying with the 2018 rules, changed our strategy as the law developed. But one of the things that was very clear was that the law would not, the fundamentals of privacy that would be envisaged in any of the law that would come about would not change drastically. And therefore, there would be a very minimal delta of change or disruption that the organization would face. So we had already started preparing. We were moved towards taking consent. We started doing privacy risk assessments for all our projects so that we could understand the risks, where the data sits, the kind of data that we hold, etc. So it's been a long journey, and therefore, when it comes to Unilever, we've been a little ahead of the curve in terms of preparing for the law. I think I'll not get into what all needs to be done from a Unilever perspective. I think right now what we are focusing on is building awareness again, because that has been something that we've been doing for the past 3 years. But now with the law taking its shape, we want our senior management, our managers, our IT teams to realize that the implications of non-compliance are huge. Unlike a 1,50,000 fine that are statutory fines in other laws, there's a clear 250 crore implication that may come about, financial consequence that may come about. So raising awareness, I think, not creating panic, but raising awareness to the extent that they start coming and having these discussions, relaying information with respect to where the data sits, things that we've missed out in the past. I think that is something that we are doing. And we are plugging all the gaps with respect to whatever we've learned over the 4 years, because as Mitali mentioned, there's a lot of cost implications that would come about with compliance. And that is something we were a little slow on, because we did not want to make infrastructure changes, etc., without being clear about what the compliance requirements would be. So with the law taking shape, we now can make those. So that is something that we are planning: an audit, organizational audit, technology, as well as not only a legal compliance audit, but a technology audit to understand the architecture, the processes that exist, because cybersecurity processes have always existed in an organization like ours, whether it's Eureka Forbes or Unilever. We've been conscious about that, but to ensure that the processes are in tune with a personal data perspective or privacy-centric design is something that we're looking at, and we will try to understand whether there are improvements there. So that's what we are focusing on for the next couple of months with this law taking shape now.
Thanks, Bibhav. That was rather insightful. And Mitali, this question is for you. Eureka Forbes must be a data fiduciary for, say, hundreds and thousands of, say, customers, apart from their vendors, employees, and other third parties. Now, how big a challenge do you anticipate in providing the kind of notices and seek the level of consents which the law expects.
So, well, one comes after the other. You have the LODR coming in, and now this. So it's like a host and a huge data going to and fro everywhere. Agree completely. Ours is a setup, and I agree with what Vibhav had already said. So there's a lot of data. So handling data, collating data, identification of data. Because for us, it's both ways. Eureka has a huge setup in terms of the service segment. So everybody knows every household would have a water purifier. Let's not say a vacuum cleaner, but certainly a water purifier. So we handle each and every day a lot of data which is shared by consumers in terms of, either it's a consumer complaint or it's an AMC which needs to be booked. And there's a lot of voluntary data which comes into our system. So you voluntary, and there is and that would be the case with most manufacturing industries. You are there on the e-com platform. There's a lot of internal data which is there, a lot of customer data which is there. A lot of us are into contract manufacturing, buying of spares. So we have huge lot of agreements. So data will flow out. There are standard protocols which are there. So there will be a lot of rush in and rush out of data, so to say. But at this point in time, how do you handle data? How do you identify data? Ours is a setup as of now of Eureka, which is we are main partners are PE based out of the US, and hence there is a lot of data which every day gets transferred between India and US. So that from that context and concept also, all of us are right now evaluating. So there is a core committee which has been formed, and honestly speaking, we are not as mature as Unilever certainly, but yes, we've done quite a bit of homework. The architecture in terms of our IT is there. They've been working at the back end in a preparation for this particular bill. But yes, what kind of policy guidelines needs to come in? What kind of awareness needs to come in? Because ours is a setup where we have service technicians who are not that aware of these kind of major changes. They are not as educated. They are as good as plumbers on the ground. How there are apps that are being used day in and day out, because that's how we prevent data leaks and things like that. So there is a lot of deliberation going on in the background as I speak, so as to first ascertain how this is going to affect us. Number two, how do we handle and process data? And at the same time, we become law abiding, because like we have said that 250 crores and 200 crores is quite big enough. It's not easy in terms of compliance. Plus, that is where I said cost of compliance, and not only cost of compliance in terms of procurement of tools or segregation of data or investment. There has to be also a lot of investment in manpower, because there'll be a significant resource bench strengthening which will happen, because there will be a lot of streamlining of operations which will require manpower. So organizations both ways will have to look into management of data as well as management of protocols and resources.
So I have a question for both Bibhav and you, Mitali, and because as Abhishek was also talking about, the requirement for consent is almost very difficult, because every time there is a certain level of consent that you need to seek. Consent has to be constantly monitored in terms of people having the right to be able to review it. And obviously, as in private individuals, that's something that is very welcome. But as organizations, there's this concept of consent manager, which has been introduced first in the 2022 bill, and it has been taken forward. How vital do you think will be the role of the consent manager as a concept, and have you been able to identify organizations which might be able to give you the kind of consent managerial support that is required in a digitized format, so that every approval, every modification, every amendment can be tracked? So question for both of you in whichever order you want to take it.
Do you want me to go first up?
No, please do. I'll chip in later.
So see, if consent, let's pick up one bit of it, employee data. Now, each organization has its own tool to manage that particular data. So consent managers cannot be uniform across all verticals. It has to be a different category of managers. In some cases, it will be outsourced managers. In some cases, it would be the internal teams who are operating, let's say in case of internal employees using data, so it will be the IT team. In case of our kind of setup, which is the service team largely, so we have huge setup of call centers. So how do we, because most of these call centers are outsourced call centers, so there we'll have separate set of managers. So it's not possible to uniform and have only one or two category consent managers. Every vertical will require some kind of managerial support in terms of collating or maybe granting of consent or monitoring consent, and then creating a a uniform category on consent. So that's the way we are looking at it. Maybe organizations as large as Bibhav may have an internal team set up. We are not looking at setting up any internal team as of now in terms of only consent management.
So, Bibhav, I mean, do you see consent management as a human process, or do you see consent management as a digital process?
If you see how the law has envisaged consent managers, it's entities who are registered or certified by the government to manage consents on behalf of the data principals. Now, I have very limited understanding, because one of the things in the last 4 years when you've tried to understand this, and this has been, as you rightly pointed, it's featured in the earlier drafts. And while there has been accountability of managing consent, they've not really envisaged how they're going to. As Mitali mentioned, there's employee data. Let's take employee data. Okay, that's internal data. We'll manage it. Let's take consumer external facing data for an organization. And these data are managed not only in technology infrastructure and architecture is complex. We do not store data. It's not that there's only one S3 server where everything is based. It's not as simple as that, right? It's across third parties, as Mitali mentioned. It's there with their technicians who may house it on their phones, whether it's in the servers of Amazon, it may be on-premises servers, maybe e-commerce D2 websites, etc. Right? What I have not been able to understand, first, one of the inputs that I would want is that if they want to create something like a consent manager, it should have accountability and operability across data principals and data fiduciaries. That's how it needs to be. It can't be that you're managing it only for data principals and you come and tell Eureka Forbes or Unilever that, oh, this person wants to delete the data. I don't know whether if that is the intent, or the intent is to really manage, because I think the intent is to manage deletion of data, retention of data across data fiduciaries. If that's the intention, then I would really, I'm not the right person from a technology point of view as to how they'll integrate it. I don't know how they can remove data across all of these platforms from data fiduciaries, their data processors, etc. So I'm really waiting to see. Just as in when I've had engagements with law firms or experts who know much more than what we as in-house counsels would. They've given us examples of the financial sector, RBI using certain of these kind of mechanisms to relay data between banks, etc. Right? I'm assuming they'll need to rely on some of these models to do that. But I'm really looking forward, if you really want, then having a system, a mechanism, and architecture which will allow consent management between data fiduciaries as well as data principals is what they should be looking at, rather than just managing for data principals. Because if that is the case, the only thing that the consent managers would be doing is reaching out to Eureka Forbes, Unilever, and asking them to delete data, confirming it to me. That if maybe that may be the services. Now, if you ask what are the kind of organizations are there who can do this, now for consent management, there are organizations like SayMind. I don't know whether people have heard of it in the call. It automates. The problem I have with organizations like that is also they also seek consent to access your inbox, email inbox completely to then manage it. And we've engaged with organizations like that, and there is a lot of gaps. They come and send you an automated email saying, delete this data from this thing. When we respond, because it's an engagement, right? Data has been collected at different points of time, etc. You want to engage with the consumer to understand what are the kind of messages are you getting? Are you getting a marketing message, or have you shared it as part of a service while buying an AMC for Eureka Forbes or for a Pureit, right? So that engagement, when you respond, no response comes in. So therefore, I don't think so. But SayMind is already doing some consent management or helping consumers do that. There are organizations like OneTrust who act as preference. They have modules which help organization to manage preferences, etc., consumer preferences on opt-in, opt-outs for this thing. So these organizations can be looked at. but I'm right now. It's very ambiguous, and I'm unclear as to what the government is thinking about the role of a consent manager under the law.
Okay, so I will, in the interest of time, move to something that I know a lot of the people in our audience today would be keen on knowing. There are probably 3 to 4 months between now and the actual rules getting framed, the data protection board being created, and the law actually being notified. So let's say between 3 and 6 months is the timeline that we're looking at. What can organizations of various scales, say, startups who can still end up being significant data fiduciaries by virtue of the nature of data that they deal with, to organizations of scale like yours and Mitali's, what can they really do in terms of, especially people with disparate sets of data sources, what can they do to really use this time well and prepare themselves for the law and the potential consequences if they don't?
So let me take this. Sorry, Mitali, would you want to go first? I'll tell you. Let me. So when it comes to organizations, as Mitali has already stated, there are different kinds of data we're dealing with. Employee data, customer data. Now, customer is business data, but one of the things that we have to be conscious is that in a country like India, and especially organizations like ours, a lot of retailers, wholesalers, technicians, etc., are sharing their personal mobile numbers, email IDs as part of business data, and therefore you'll have to treat it with some significance. May not be at the same sensitivity as a consumer data. Now, employees, customers, vendors, etc., as Fox. Employees would be the second, and the biggest one is consumers, external facing consumer data. Now, how do we start about? I think a step-by-step approach would be to first raise awareness. Start taking sessions in your leadership teams. As Mitali pointed out, resourcing is important, right? If you do not have a dedicated person, you'll need to dedicate someone. May not be a DPO right away, but someone who can invest their time completely, not doing other things, whether it's a tech person as well as a committee or of sort, which can really look at the organizational data setup and data processing activities, right? So that's one thing. So relay it through awareness that this is coming. We need to prepare for it. So people are willing to give their, senior leaders are willing to give their mind space as well as invest in resourcing and allowing access to the systems, etc. Right? That's the first thing. I'm not getting the training of people because I'm more focused on how to prepare for it. So awareness amongst leaders. Then you go do a data audit in terms of understanding what kind of data do you house and where is it housed. Employee data, where is it sitting? Is it sitting in a CRM or Excel sheets or registers, etc.? Fortunately, it's only applicable to digital formats of data. So that gives us a better playing field than what Europe has had to deal with. But I think getting a lay of the land or the organization is important in terms of data, data sets that you process and for what do you process. The third thing is understanding your IT and security infrastructure, because what I firmly believe and I've learned over the last 3 years is that 50% of your compliance or headache would go away if you can be assured by your CDO or CTO that your data is secured, whether it's personal or non-personal, it's secured in certain ways. There are ways that we ensure that any app that is developed undergoes certain cyber assurances, etc. Right? So understanding that and trying to figure out whether personal data is also covered, apps, activities undergo that in terms of digital processes, etc. The fourth thing is whether I would call it a DPO, because DPO is required only for significant data fiduciaries. But irrespective of that, having a privacy advisor who's well versed with the law, who people can get into discussion, understand what are the nuances of compliance, because there's a lot of ambiguity still there. So if you want to make investment right away, you need someone who is well versed of the evolution of the law in India and the expectations, so that they can tell you, okay, hold on, don't invest so much on this. These are the things that you can invest and start preparing. These you can look at when the regulations come about. I think once you do that, I think it'll be good. I know every organization may not be able to do that, but large organizations that think that they would be classified as SDF should get organizations do a technology and a data audit for them, an external one, which gives you certain reassurances. It's a quick one. It may not be exhaustive. I've done, I think, upteen numbers of audits over the last 3 years, and none of the audits can guarantee you a complete 100% compliance, because they'll do audits of processes or activities. Organization-wide data. Tomorrow, I as a person may download my reportees, performances, or maybe personal details and store it in my laptop or my personal laptop, or store it in a Google Drive, which is not as per my organization policy. So there's a human element of compliance also. So training of employees becomes the next step. But I think these 4 things, I think if you manage, is how you can start in the next 3 months to comply with the next 3 to 6 months to start preparing for compliance with the law.
That is extremely insightful. And Mitali, over to you for your inputs.
Audit, identify, decide on a roadmap on how you handle that data. Preparedness, awareness, it has to come top down. The senior management, the core management team needs to be made aware. There are, I'm sure, across organizations, presentations are ongoing. It's not supposedly a very easy act to interpret, while it's a diluted version, I would say, of what we had seen previously. But even then, who is going to be taking up the DPO role? How do we have a team in place? Whether it's going to be a cross-functional team, because it'll be a business strategy team, maybe in some organization. Most organizations would have a CTO, and then the GC's role becomes even more cumbersome. So all that taken together, it has to be a cross-functional team, according to me, while it may be headed by a DPO. But as of now, yes, audit, identify, manage handling of all of these is what we can do for the next few months.
So I know we are, running out of time, but Kanishka, Abhishek, if you have any further questions for Mitali and Bibhav, then if you can ask, and otherwise we can move to the audience and take their questions as well.
Sure. I think, just one last question from my side is that, of course, what we understand is, the Act definitely is doing away with the SPDI rules. So my question is, what do you think, what impact might it have on the overall privacy scenario?
Well, most organizations will tread with caution because the numbers are quite high. But I would be rather more keen to see what comes up in the rules with respect to enforcement and governance, more so from the broad perspective, because I, for one, would not wish this to be lopsided to the extent the way we have seen the Consumer Protection Board operate. Because by default, in most cases, it's the right of the consumer and they'll get away with it, even if some of the contentions and some of the complaints are not legitimate. Similar is the case here, that in terms of a data fiduciary, if you are taking to the board just to say that yes, you are incorrect, that will be not the right way to do it. So I would still await the governance of it, because that's where organizations will face the heat. Because in-house, you can manage a lot of things, you can form teams, you can identify, you can audit, you can create a roadmap. But when it comes to complaints, governance, and then how the board is going to take this up is what I would like to look forward to.
Bibhav, would you also want to take the specific aspect of SPDI rules being done away with? Do you think
absolutely
it will be replaced with some other equivalent rules?
Absolutely. So I'll to be very honest, I need to be a little political also. So I think one of the things we need to accept, and I don't think so, there's no denying about it, is that these rules have never been enforced properly. It's been there for ages. I think very rarely have the SPDI rules have been enforced. I think there are very few organizations or limited organizations with respect to when it comes to having a grievance officer. The law itself is so lopsided that it says written consent for processing sensitive personal data. Now, every organization processes sensitive personal data of their employees. Let's forget if you don't process for consumers, we do, right? And therefore, I don't think so the enforcement was something that was being pushed by the government. There was no authority as such to really implement this rule. So I understand that it's the concern is about the categorization of sensitive and personal data the way we have in other jurisdictions. But what I would assume is that as the regulations progresses and evolves, what they should classify is having proportionate compliance depending on the sensitivity of the data. So if and then I'll give you an example, a very basic one, that having a 128-bit encryption for mobiles and personal data, like address, etc., vis-a-vis a 256 encryption, as well as having more measures of pseudonymization or anonymization, etc., having being placed by the government through regulations, is what I would look at. I think there's, from an activist point of view, if I was on the other side of the table, there would be concern that why did you remove the specific protection for sensitive personal data? But I think because of the polarizing views and the bill being stuck to manage expectations at everyone's end, I think the government decided to simplify it and come up with something. And we've heard the minister time and again that the regulations is something that they would want to evolve as they learn. And that's why I'm hoping the SBDI rules repealing Section 43A under the Act is something I'm not too concerned of right now, because it was anyways not giving the required protection to the consumers or the people, the public at large.
Sure. So I think we're slightly behind schedule. We've probably reached a point where a number of our esteemed audience would like to ask some of the questions, or we can take some of their questions as well. So thank you everyone for joining today's session. I know that we've already reached 4 o'clock, but and we've tried to answer as many questions as we could over the chat session, but there are a few remaining. So Bibhav and Mitali, we will ask, we'll start with you, Mitali. There is a question on what will be the impact to the service industry. Like, we get calls from call centers on behalf of different banks, financial institutions, etc., which is a clear violation of personal data, of data principle. As per Act, notices to be sent to such DP by such authorities. So what exactly do you think will be the outcome of this on the call center operations of different organizations?
Thank you, everybody, and good afternoon. Yes, very rightly so. See, all of the data which is there, which is in a bank, let's say it's a data fiduciary, it will forward this data to the data processors. Each one in the chain would be affected. Each one of them have to go by the consent format. There has to be a notice clearance and will be required to follow each and every aspect which has been laid down. Now, to add on to it, we are currently seeing, let's say, 33 sections. We still await the rules. The nitty-gritties will come into being. But having said that, everybody in the chain would be affected, whether be the service sector, whether be the core functional segment. Also, the fact that there has to be a concerted effort, and it requires under the Act to maintain an audit trail. So it's very critical for everybody to sit back and take note from here, maybe 4 months down the line, 6 months down the line. This is the most important time where a lot of bench strength, and I keep on saying this, that there will be a lot of manpower, a lot of cost involved in it. If we have to do this rightly, all of the organizations, be it service, manufacturing, otherwise, including healthcare for that matter, a very critical place where a lot of data is stored, and that data is certainly very sensitive. There has to be an audit trail of all of this. So each one has to have some amount of accountability, obligation, process flow, audit, consent, notice. All of this have to be followed.
Thank you. Yes, I completely agree, and thanks for highlighting this. Question to you, Bibhav, from Jayadevan Ambak. Would blockchain-based tech help in data processing and consent management? He's thinking aloud and wants to know your views.
So I think as I said, it'll be a little technical from a legal perspective for me to really opine on that. But I have read a lot about blockchain being used for consent management. The Ethereum, there were some articles that I'd come across on the Ethereum platform being used for consent management. So it looks like a possibility. I think time will tell, and whether there are developments in this area in other jurisdiction. It is a more secured way of communicating. It's been proven technology, right? So therefore, it is possible. But I would limit to find that it's a possibility, but I do not know whether that's something in the near future or later on.
Sure. Just for everybody, we will continue for another 10 minutes because there are just a lot more questions, so we might not be able to answer all of them in the next 10 odd minutes because we're already past the time. But whatever questions are left, we'll try and get you responses at the earliest whenever possible. Some of the questions are very required opinion, legal opinion almost. So it's a little difficult to provide that over a, for any of us to provide that over a brief chat session like this. But you can reach out to us and we can try and assist you to the maximum extent possible. With that, the next question to either of you, Bibhav, Mitali, from Ashish Agarwal, it says, during meetings, people provide their contact cards voluntarily. Is this considered as consent, or we'll still need to take consent?
So I would treat it as legitimate use. I think the government has taken care of it as deemed consent earlier, now legitimate use, and I would say that that's what it's covered under. You wouldn't need to give a privacy notice and this thing. But however, taking that contact detail and putting it as part of your remarketing database would be a problem. So that's the limited, I think.
Exactly. I think that's the whole point, that the Act allows you to use certain types of information, but it's for a specific purpose. So you have to clarify what purpose this information is.
What is going to be the key to this particular provision?
Right. So that is something that we'll have to keep in mind. The next question from Suresh Tilokani, very interesting question. Can we profile our customers or as the same is prohibited? I do not know whether the second, let's just stick to the first part. Can we profile our customers? Bibhav, do you want to take that? Or Mitali, whichever, whoever.
Please, Mitali, go ahead.
Yeah, no issues, Bibhav. So I think it will be difficult at this point to give a yes and no answer. But in terms of profiling, I think there'll be and that is where your audit trails, given the data processing time, the data possession time, it's like 7 to 8 years. LODR has just spoken about that you need to maintain data for a period of 8 years. So once the rules come out clearly, will we be able to define all of these things?
And if I can just add to that, as far as international, businesses were concerned, earlier there was a specific inclusion of profiling as also being prohibited in the 2022 version of the bill. But in the 2023 version, the portion on profiling has been deleted. So there is no reference to profiling anymore, which suggests, at least as far as international organizations operating from outside India is concerned, that as long as they're seeking information only for the purposes of profiling and not for selling of goods and services, then it will not be included. But this is a very broad view basis what existed in the 22 version and what exists in the 23 version. Bibhav, if you have another thought, happy to.
So under the Act, there is silence. So once under the Act, there's a bit of a silence right now. Correct. Maybe it can come out in the rules, not that explicitly. Yeah, Bibhav, go ahead.
No, so I think behavioral monitoring and tracking of children is something that has been expressly prohibited under the bill. As Mitali and you mentioned, profiling is not. However, you'll have to look at it in context as to what is the kind of notice you've given to the consumer to whether you can use that data for profiling, etc. So if the notice is covers the aspect of profiling for remarketing, etc., that's something you'll be able to do. We're hoping that. But as Mitali mentioned, rules will tell. I am quite positive that profiling would be, because it's one of the very key part of commerce right now. And it's not only beneficial for organizations like us, it's beneficial for consumers also. I would want to see shows that are relevant for me from that I watch on Netflix. The recommendation engine provides me that. It's profiling of my interest. Similarly, for Google Ads, I wouldn't want to see ad that or show that I may not be interested. So it's in the benefit and interest of both consumers and organizations. I think it would be possible, but as Mitali said, rules will also have to be looked at subsequently. And
probably as an outcome of the enactment, while it's still not formally in place, I noticed that in YouTube, if you did not allow them to track your history, they would still provide you with a page where basis your previous inputs, they would profile and provide you inputs. But from yesterday or day before, they've stopped that. They've actually if you do not allow them to check your history, they've stopped profiling, and therefore there is no information available in your home feed. So which is probably the beginning of how people are viewing it. But how, to your point, how this will actually pan out, we'll probably have to wait and see. Several more questions. In the interest of time, we'll probably take a couple more. There's one from Hetal Vishwanathan. For HRM purposes, the data is shared with third parties. Then what is the organization's responsibility of contract services consultant breach? Bibhav, if you want to take that.
So one of the biggest concerns that organizations need to have is third-party risks under this, because there's the accountability on the data fiduciaries. So if you have third parties who are processing your compliance for your employees, or even providing service, any service, whether it is from a marketing perspective, HR perspective, service perspective that Mitali spoke about, the accountability of compliance, any lapse on account of negligence by the third party rests with the data fiduciary. And therefore, it is highly important for organizations like now to streamline their vendor processes, understand who they are working with. Data vendors need to be evaluated. Do they have the right infrastructure, right security practices? Will they be able to house the kind of data with the same seriousness and sensitivity the way organization that is handing them the data would want them to, and as the law would prescribe? So therefore, that is one thing that would give GCs like Mitali or any one of us sleepless nights, because that's one process that you'll have to streamline, because at the end of the day, we will have limited control on how a third party works. And therefore, you need to have governance processes where you can tell the government or the regulator that I've done my bit, a safe harbor kind of sort, that I've done my bit. Now you can't find me 250 crores or 100 crores, 50 crores for someone, a technician going and start sharing the data with someone else. I've given everything. I've put in security protocols on the app. So I think that is a big risk that we'll have to manage. And I think as CTOs, DPOs or GCs and tech people managing data, that governance bit of third party is highly important.
Okay,
just to add on to what Bibhav said, see, the Act does not directly provide you a chance to go, it doesn't speak about a police complaint and things like that. So it's not easy to say that while the data has been leaked by a third party, be it a vendor, be it an IT service provider, how is the data fiduciary able to take that person to task? So that is where I would want to see more. While you may have your policies altered, your agreements very binding, tight, whatever, but at the end of the day, it is going to boil back to the data fiduciary. What is very, very important to see whether the data fiduciary has any right to really go against the person who's leaked the data, person who's mishandled the data. So that's not what is very, very clear under this Act. Those are the nitty-gritties that I would like to see. And I'm sure many of the industry experts are waiting to see all of that, because if I am fined, I would also want to see that if I am not any which ways wrong, what remedial measures can I secure myself with?
Okay, one more question. So I am personally not fully aware of the implications, but if either of you know, Mr. Nitin Kumar Singh, and I had misread it as ISO 27001, but his query is, with regard to ISO 27701 and the distinction between that and the DPDP Act. I must admit that my knowledge of the ISO 27701 is not enough for me to be able to answer that. So if either of you are aware of this, we can take that. Otherwise, if you have time, maybe take one more question and then end today's.
I have very limited. I think it's the privacy information security standards under BIS is what they're referring to. I think 27001 is the IT security standard. This one is privacy information security standard, something to that extent. I think it doesn't. The current DPTB Act does not provide details and specificities of compliance. This one provides details on how your systems will can implement a privacy by design or privacy-centric approach. I don't think so. They are at variance till the rules come about. Right now, the Act would say, would prescribe that you would need to have a privacy-centric approach or security of the data. I think that is what the BIS would do. Organizations like us can get certified under that to show that we've done enough. The way the IT SPDI rules recommended a 27001 compliance, if you did, if you wanted to show reasonable security practice. I think that's what. So, in my limited knowledge, I don't think so there'll be a variance right now unless the rule comes and speaks specifically about it. The Act doesn't go at variance with the BIS standard.
Okay, we'll take one last question and end. And this is from Misha Bhalla saying, recently we've incorporated in our all types of service customer vendor agreements an enabling clause for sharing their data within our group companies, which is located out of India. Are we now again required to take written consent under new law?
Yes, the Act says that there has to be explicit consent, but I would presume that once the rules come in, because the consent talks about different languages in which the notice needs to be given. So we'll also have to see whether within the country, whether we are looking at different languages or international languages. So in what format would you need those consents is something which once the rules come in, very preliminary, because it only talks about, I think, 33 sections and one schedule to this particular Act. But once the rules come into play, all these things I'm sure would be, and that's how the time has been given to the government and to the board to formulate, certain directions to this particular Act, including what has been defined as reasonable timeline. So everywhere it's like within a reasonable timeline, within a timeline which is sufficient. So all that will come into play slowly and steadily. But a lot more needs to be seen as we go forward.
Thank you. Thank you, Mitali. Thank you, Bibhav. And of course, Kanishka, Abhishek, the entire team of Lexplosion who has worked tirelessly on making this a successful webinar session. And of course, most importantly, to the entire set of audience. There are several questions which we have still not been able to answer. My earnest request to each one of you is if you could just reach out to us over email. Our details will be provided. Please do so, and we will try and respond if required. We'll get back to Mitali and Bibhav and take their views as well and get back to you. In the interest of time, we're stopping here today. Thank you very much for attending the session. The recorded version of the session will be made available in most social media platforms, so you'll be able to access it there. Thank you very much.